Good morning, everyone. It's 11 o'clock and it's time to start. I am very glad to welcome you today to another Mobile Height speaker series. This event is part of the speaker series organized in collaboration with our members, Potter, Clarkson, Brand, and Sacco. All of them recognize IP law firms who share their knowledge and best practices on intellectual property topics. And today on stage, Potter Clarkson, who will guide us through all the steps that a business can take to build a trade secret strategy. My name is Carolina Garces. I am project manager at Mobile Heights, and today I will be guiding you through this interesting webinar. But before we start with this agenda for today, I would like to inform you about the house rules. Very important for you to know that this webinar is being recorded, and we encourage you to have your camera on, but in case you don't want to be featured, please turn off your camera. We highly recommend you to add your name and company's name in your Zoom alias, and you can find information on how to do that on the chat. Today's session will have 3 main segments, 15 minutes each, and you will have the opportunity to ask questions. Finally, you will find this webinar on our Mobile Heights YouTube channel and this presentation as well in our webpage. Today, we welcome Potter Clarkson, a full-service intellectual property law firm. They are very well recognized for their approach that mixes technical, business, and legal expertise and provide counseling within areas such as patents, designs, trademarks, litigation, among others. I will first welcome Christopher Harlan. He's Senior Associate at Potter Clarkson. Christopher, the floor is yours.
Thank you, Carolina, and good morning to everyone. I shall share my screen with the presentation. So, as has been said, we're going to be talking to you today about trade secrets. As we're going through the presentation, please feel free to ask questions as we're going. We'd rather have this as more of a conversation than as just a lecture. Hopefully it makes it more interactive and a little bit more interesting for you guys. Get these slides working. We're going to go through a number of different topics within the area of trade secrets today, all the way from what a trade secret is, how it compares to other types of IP and other types of confidential information, which isn't all the same. We're going to go through some best practice points, and then we're going to go through some specific learnings from industry as well. Potter Clarkson is a large firm. We have offices in Copenhagen, in Lund, in Stockholm, in London, and in Nottingham in the UK. I'm not going to spend a long time on that. Instead, I'm going to pass over to my colleague, Camilla, who will be talking to you first, and my colleague, Graham, is also here, who will be talking with us today. Camilla, on to you.
Thanks very much, Chris. I'm really happy to do this talk, as I find this topic really interesting. Sometimes we work with kind of narrow IP, but I think trade secrets is a kind of IP that is relevant to all businesses, at least to consider. I'll just wait until we have the presentation. You have a black screen, Chris.
Technical issues?
Yes, works now. Perfect. Yeah, so please jump in with the questions, comments, any thoughts you might have. I will start by saying that we have too many slides, so I'll jump through some of them quite briefly, but you'll get the slide deck afterwards, and you can take a look when it's all peace and quiet and with a cup of coffee, and then please get back if you get any questions afterwards. So I think in the area that you're all working with, knowledge is key. It's very important, and it's an asset to all businesses. And to explore that and get the full value out of the knowledge that a company has through its employees, it's really important to protect this knowledge, or at least to consider how to protect it. And trade secrets is one way of protecting this knowledge, and of course something that most of you will benefit from at least considering. I see it very much as converting knowledge into a tangible asset, because trade secrets are tangible assets. They can be licensed, they can be sold. And they can be part of collaboration agreements with collaborating companies. So it is an asset that potentially can be very valuable to a lot of companies. Also, I see it very much as creating a competitive advantage in the market. So if you have knowledge that is just flowing out of the company, you risk that your competitive advantage would be hampered by competitors just taking on that knowledge. So if you're not doing anything actively to protect it, the angle that you may have in the market may in time be less of a value compared to when you start. So from a strategic point of view, I think this is a very relevant topic to discuss, even at a board level. How do we handle trade secrets? How do we want to work with trade secrets, and essentially to have a trade secrets policy in place, so everybody is aware of how we deal with trade secrets. For many companies, this will be a journey, and most companies that we speak to are just at the very early stage of this journey. So hopefully this presentation can spark some ideas and give you an idea where to start and an idea of where you want to end in time. So you should not feel that you're not doing it wrong because you're not doing anything right now. It's hopefully you will have an idea where to start after this. So I very much see it as a journey. Can you take the next slide, please? So very brief on the history of trade secrets. In the old days, it was basically just country by country, and the law was not the same. So the EU decided at some point to make a directive to harmonize it somehow. It's still implemented slightly different from country to country, but there are some major things that are still the same, which makes it easier for companies to deal with trade secrets throughout Europe. And there are quite big similarities also with China and the US even. So in that sense, it's a big improvement compared to before 2018. Where it was implemented in Sweden, and the same in Denmark, where I am based. Can you take the next slide, please? So although we have slightly different implementation of the EU directive, there are these similarities, and there are kind of three pillars in the trade secret to consider. You don't have a trade secret automatically. You need to fulfill these three requirements. First of all, you need to have something that is of value, and it can be of immediate commercial value, but it can also be a value that you invest because you put in money in an R&D project and you get an output at some time. But at least that you invest in something, it inherently has a value. It has to be secret, so you cannot tell anybody about it. It's not like with patents that at some point it will become public. If a trade secret become public, it's not a trade secret anymore. So it's a really important thing. Also, you need to do something internally to keep it secret. You need reasonable protection measures, and it can be simply having a layer on who has access to certain knowledge. Because if you don't have that kind of protection, the knowledge will just flow. So you basically need to prove that if you are an R&D, you would have a certain pool of knowledge, maybe to a process or a specific product. But if you are doing marketing and sales, there is no need for you to have that specific knowledge, and vice versa. It could be a client list that is important in marketing that the R&D people do not need to have access to. So the reasonable protection measurements is about figuring out who needs to have this knowledge and who need not have this knowledge. And I think in most companies, it's not something that you consider every day. Who do you, discuss things with? Yeah, next slide, please. So definitely there are things to consider, whether you would have a trade secret or not, and whether it's worth going in that direction. Clearly, there are some things that are just known outside the company, that is public knowledge. So the more people know around you, the less likely it is that you would have a trade secret. The same goes for employees. Who knows what? Is it something that if you work in a certain industry, you would just know these things? Or is it very specific to this company? Also, have measures been taken already? So the knowledge has not flown out of the company and is public? Or have you actually tried at least to keep it safe in the company? And then, of course, the value you would have to figure out, when is the value? Is it a future value? Is it a value of today? Or in time, will it still be relevant to keep a certain thing as a trade secret? Because maybe the value is not what it was before, because technology is moving quite fast. So it's definitely not a static thing. It's a thing that moves and need to be looked at certain points. Yeah, next slide, please.
Camilla, can you expand on what happens if a company doesn't take the appropriate steps to show that the trade secret is secret, has value, and that proper measures have been taken?
If you don't do it?
If one of those aspects is missing.
Yeah, basically, then you will not have a trade secret anymore. And clearly there are some of the things that are more difficult to prove, but you need to think of it as that if you have a trade secret, you need to be able to prove to somebody that you are actually in the possession of this trade secret. So you need to be able to document that you have it, to have a system in place so that you can use in terms of a judge or whatever. So the systems are key in handling this and having a policy so people know when to do what, so to say. Yeah, so in practice, I think I've said most of it. It cannot be public, and it has to have this value that I'm talking about now or in the future. And in terms of protection, it also is a big thing on HR. So when you get new employees, it's important to make them aware that this company has certain trade secrets, and then they are allowed to see these trade secrets, and it is trade secrets that are supposed to be in the company. And likewise, it's very important to have a policy in place. So when you get new employees, that you don't get a trade secret that you don't want to have, because if you get a new employees, we work with very highly skilled people, and often you would have a limited pool of people working in a certain area. It's even more important to have straight lines on what is knowledge of this company and what is knowledge from the company you came from. So simply to have it in contracts, and also discuss with people when they arrive that there are certain things or knowledge that you are not allowed to use from your previous employee in this company, because you risk being contaminated by new people coming in, and it's something that you want to avoid, of course. And clearly there are boundaries as to what you can do, but speaking with people is at least a good place to start and discuss the knowledge that you bring to this company. Are you actually allowed to use it or not? And I know some companies has the luxury they can actually take in a person and put them in another position for a period of time and then get them back to what they used to do. But I think for most companies, it's not really an option. So at least it would be a good start to have that discussion. And again, if you don't have your trade secrets documented, how can you allow new people to see these trade secrets if you don't have them on file? So that's yet another good argument for having a documented trade secret.
There's an example that we can give in relation to when you bring a new employee in. And let's say you bring a new employee in who's an expert woodworker, to give a very quick example. You employ that person for their skills in the woodworking and all the skills they've learned in using a lathe and using tools and equipment. But at their last company, they might have realized that if you freeze wood before you sand it, you get a much better result. That may well have been a trade secret of the previous company, which is why they always had such well-polished wood. And that is the sort of thing that, as a company, you may want to have knowledge of, but getting that information from a new employee might be putting you at risk of having stolen someone else's trade secrets by mistake. So, just a very small example on that. All right, Camilla, I'll give you the next slide.
Yeah, and I want to add to that, because I also think as a new employee, it's nice to have straight lines, because otherwise you would maybe worry that you bring on something that you intentionally, shared without knowing what you were actually sharing or being aware of it. So I really think it goes both ways, this aspect. I think the cool thing about trade secrets is that there is a lot you don't have to do. A trade secret can be both technical and non-technical thing, but you don't have to record it at any office like you would do for trademarks or patents. You don't have to pay any fee. You don't risk to get your knowledge published, because essentially you don't want to do that, because then you don't have a trade secret anymore. And you don't have a static approach, so you can abandon a trade secret and make a new one as knowledge develop. There are no marking requirements, there are no specific guidelines, and there are, essentially no time limits. So you can have a trade secret forever if you like. You can protect it as a trade secret when you like, if you have not published it anywhere. So I think it's just a nice place to start, considering what kind of knowledge do you have. Do you want to protect it as a trade secret, or do you want to do something else with it, like, for example, file a patent? And I know later on this presentation, Green has some good examples on when to do what in this technical area. Yeah. Yes, you can take the next one, Chris. I think just to kind of set the frame, because we are also focused on technology, because that's the area that we work in and also find very interesting. But trade secrets can be a lot of things. It can be formulas, it can be patents, it can be methods, it can be client information. It can basically be a lot of different things. It can also be things that are not working. And if you look at the EU directive, which is a nice guidance, you see technical knowledge and you see commercial knowledge or data. So trade secrets are not just a thing to consider if you work in R&D. It's definitely also a thing to consider if you work in sales, for example. So it's relevant for the whole company, I would say. Yeah, just briefly, a lot of examples. You can take a look at this more, but algorithms, software codes, data, also test data and training data. There's a lot that can be seen or protected as trade secrets. Yeah, I did that a little bit already, but trade secrets are obviously confidential information, but not all confidential information needs to be a trade secret, because you have to consider the value. So I think that's and maybe also the difficult part. When do you do what, and when do you see a value in things? Because it can be now or it can be in the future. But I think the good thing with trade secrets is that you can start by having a trade secret, and then if you find out, oh, this is not really a value to us anymore, you can just abandon it. You don't have to do it at any office. You don't have to pay a fee or be worried about anything. As long as you have asked yourself the question to begin with, then you basically have all options open, I would say. Yeah. So a lot of what we do is patent work, of course, and there are some big differences on patents and trade secrets. And I would say you can again start with the trade secret, and then you can consider whether you want to file a patent on it at some point. You do not risk the opportunity of doing that. So it's again, I don't want to run through all of this, but I think a key point is also about how long can you have the protection. On patents, it's 20 years, and on trade secrets, it's potentially forever if you want that. And also the costs. There are no immediate costs. There are, of course, some internal costs in setting up the systems, but there are no official costs to have a trade secret. Yeah, I think you can take a more detailed look on this, unless you have more things to add, Grima or Chris.
Camilla, I have a question there, because I think many companies, they have this big question between what do I use, a trade secret or a patent? And of course, as you said, both have pros and cons, the cost, the protection time. But when it comes to deciding, what is it, the key point that you have to take into account to say, I go for a patent or I go for a trade secret?
Yeah, I think that is the key question. I would like to save that question for a little bit later, because Grima actually has a nice presentation on when you do what, or when it's a good idea to do one or the other. And yeah, so if that's okay, we will save that for a little bit. But it's a key question. Yeah, we can take the next one, please. Yeah, again, this is a little bit of a gray zone, and I don't have the defined answers here on trade secrets and know-how, but definitely know-how is something that you have in your head. So if you wish to keep the knowledge, you can of course have it in your contracts, but know-how can also be public knowledge, and it can be of value or it can be of no value, but it's so you don't have to take any steps like you do with trade secrets to protect know-how. So it's kind of the same, yet a little bit different. But if you think that know-how should be protected, you should definitely take it and use it, the way on the 3 pillars, and try to protect it as a trade secret. Yeah, do you have anything to add on that, Chris or Green?
Back to the example we gave before about the freezing of wood, the actual step of doing that might be a trade secret, but the knowledge of how to do it, the skill the person has in doing it themselves, and their knowledge of how to set it, or maybe a way to put it in there properly, just their experience in sanding afterwards might be know-how, because it may be their skill in applying that trade secret. And so the two start to blur a little bit there, but you can see a little bit how they're distinguished. Graham, I can see you've muted as well.
Yeah. And Camilla, one of the questions I sometimes get asked by clients is, does their trade secret have to have a certain amount of value? Is there a value threshold? And how they establish that? I don't know whether you've got any experience of that, Camilla.
I don't think, I asked the same question at a seminar I went to some time ago. And I don't think there is any key answer to that. You can't put a certain amount of it, but you can look at how much do you invest in a certain project. And when you do your own calculation or your own business case, you don't invest in something unless you actually think that you will have, that you will earn some money at some point. So I think that's, to begin with, is actually enough that you can make that reasonable calculation on value, even though you don't know exactly how it will turn out in maybe 2-3 years time. But at least investing in something is also inherently a value. And then yes, you can of course have a real value if you are already selling something. Where you can go back and say, okay, what is the value here if we could not sell this product anymore because somebody else did it and took our market because they stole our trade secret.
Yeah. So if you have confidential information that you feel would be of interest to a competitor, that almost by definition means it has some value and therefore is a trade secret. Would that be correct, Camilla?
Yeah, I think to some extent it's a good way to start thinking about trade secrets. Where is the value? And if you were to stop doing what you're doing, what would be the consequence in the company? So I think that's a reasonable place to start when evaluating what is of value and what is not.
Okay.
And I think also because this has happened relatively recently in 2018, nobody has clear answers to this at this stage. So it will definitely be something to look upon on new decisions from the courts around Europe as well.
Okay, thanks, Camilla.
Yeah, so turning back to this, it's an area that is not standing still, that's for sure. The law has changed in many jurisdictions, and it takes some time before cases emerge and conflicts arise. And it's basically the case law all around Europe that defines how a law is implemented and seen. So, but what we see is that trade secret litigation, the numbers are increasing. Also, the tax authorities has begun to look at this because it is a big intellectual property, is a big asset in a company, and it should be seen as that. So I think in the future, we will have more cases where a company actually need to show that if you have a trade secret in one company and another part of that company in another jurisdiction uses that trade secret, you need to actually show that you have paid for it. So the transfer pricing aspect is definitely something that will become more important to be aware of and to include in your business plans and also in having a trade secret policy, because how can you discuss value if you don't know what it is? So at least that's a good starting point. Also, oh, sorry.
No, there are potential serious consequences for businesses there as well, aren't there? For example, a large company who is separate businesses, separate entities in different countries. If you're sharing your trade secrets between those companies and you never assign any value to them in any agreements there, well, if you've just been sending that information forward and back it up, signing agreements even within what is your own company, or maybe a company you're collaborating with, then you're saying that secret has no value, and you're potentially opening yourself up to someone being able to say, well, that wasn't a trade secret. It doesn't have value, therefore you can't enforce it. So there's a real trap there for companies, even just when working internally, that should be borne in mind.
Yeah, exactly. That's a good point. Yeah, and in terms of just the way that we work, it's the very nature of how we work now compared to maybe 10, 20 years ago, emphasize the need to be careful, because we share so many things, but we are not always thinking about what we are sharing or how we are laying our knowledge open to others. So basically just the technology is changing, and also the fact that we are working a lot from home and we are not together anymore makes a big difference, because you would send things around maybe more than just speaking with people. And if you send things around, it's also a risk when you speak with people, but it's just more difficult to prove, I would say. So there is a lot of things that have prompted this change towards looking more on trade secrets, I would say. Yeah, we can take the next one. I think I need to leave some space for Chris and Green also, but in terms of the journey that I was talking about, I think most companies start here. You have a lot of knowledge, you don't really know where it is, and especially it's definitely not protected. I guess in many systems, everybody would have access to the same servers or to the same folders if they like. So I think from a company perspective, most companies, don't have a practice in place that can actually be used to enforce a trade secret at some point. Nor do they necessarily have it in their contracts with new employees, and less, I think, they would have that talk with the new employees, showing them the trade secrets that they are made aware of, and also having the talk, what do you bring to this company? What do we want to hear, and what do we don't want to hear from your previous employee? So I think, to be fair, most companies are here, and it's a journey, and we want to move to the next slide, I would say. And it does not happen in one day, that's for sure. There is a big element of education also, because, as I said, trade secrets are basically something that everybody in a company should know about. They should at least know the framework, what it is, because if you don't know what it is, it's you cannot protect it and see the value of it. You need to have trade secret policy in place. And I would say, I hear a lot of companies who want to collaborate with maybe big companies. And the big companies, they actually require that you have a trade secret policy in place, because they don't want to collaborate with a company, share confidential information, and then don't know what happens to it in the company that they give the information to. So that is a movement that we at least see, that if you don't have a policy, you can actually risk missing out on big potential good collaborations. And that goes in both directions. Also, we see it quite a lot on acquisitions, that if you have a trade secret policy in place, you inherently show another level of professionalism compared to a company who is not aware of it. So even though you start on a low level with only some of the points that I have shown, I think you already show more credibility than having not done it or not considered it. So if I was an investor, and we often represent investors as well, it's something that we look at, something that we ask about. And already if we see that it has been considered and at least dealt with at some point, already there you would have an increase in your company value, I would say. So it's worth to take a look at the best practice and see where do we want to start, and acknowledge that it's not today or tomorrow, but it's a journey, and it's fine to start out in the smaller steps. Yeah, I think next slide. Yeah, we can run. It was just what I said. You can take a look at these afterwards, and the same with the next one, I would say, Chris. Just ideas. Yeah, we have put in a few slides on the disputes, basically just to show where disputes can arise. And on the next slide, we have put in just a few of the highlights on big cases. I don't want to use any time on those, but it's just to show that it happens in big companies and smaller companies and basically around the world. The next one is, you can also take a look at that one later. It's a Danish case that is somewhat related to the area that you were working in. So you can read that one in more details, but it's at least a case that is closer to home than maybe one of the big US cases. So it's again, employees moving from one company to another. So I think it's quite relevant just to take a look at the highlights there.
Well, this case may have been in Denmark, which is still very close to home, of course, for all of us. It's all under the same, the new rules are all under the EU directive that was passed, that was, everybody had to implement, Sweden, Denmark. So while things won't be exactly the same from country to country, things happening in Denmark are probably going to be very, very relevant to what's going to happen in Sweden, because the rules we've been told to implement are the same or extremely similar. And important from the last slide as well is for all of us in the software sort of area, there's an awful lot here that relates to our technology areas. Graham and I particularly work in electronics, software, computing inventions, and we can see here analytics data being up there, wireless technologies, test robots, wearable tech, business plans, not even the wearable technology details itself, software for finance, software for medical care, autonomous driving technology. There's an awful lot, so it doesn't really matter which technology area you're in. You probably have some trade secrets that are going to be valuable. Sorry, Camilla. There we are.
Perfect. Yeah, but that's exactly right. There's just, yeah, you can take the next one, Chris. I think in this slide is more to highlight how can you think if you end up in a situation where you have a trade secret and you are worried that somebody else has stolen it from you. Of course, you need to be able to show that it has been secret. It has a certain value, and that you have measurements in place so it is protected. And then was the intent to steal the trade secret, and what is the damage that this has caused the company. So these are kind of the three key things that you need to consider before you decide what to do and whether to take any action, I would say. So it's a good thing to keep in mind the things that you have to prove should you end up in a situation where somebody took something that was not theirs. Yeah, you can take the next one. It's just highlighting the fact that that it's not just words, it is actually happening in the real world. And it involves a majority of different technologies. And for sure in tech, there is a lot of trade secrets that are worth considering to protect, I would say. And then I'll leave it to Chris and Graham to talk about more detailed things in your technical area. Thanks.
Thank you, Camilla. So this is actually coming right to Carolina's question from much earlier on. So thank you for asking that one, Carolina. We're going to, in 5 minutes, I've put together this whole presentation on it. I promise. It just happened. No, this is all planned. So to patent or to trade secret, it is a very important question and it's not a simple one to answer. And there probably isn't always an exactly correct answer, but it has to be driven by the commercial needs of the business. Everything in your intellectual property strategy should not be, I should get a patent because people say patents are good. I should keep this as a trade secret because trade secrets are good. It should all be driven by what does your business need commercially. Do you need patents that you can show to investors that are going to help drive you forward? Or are those investors going to be comfortable enough with you having a register of trade secrets? Is that going to be enough? Can your invention be reverse engineered? If you are running on the back end in a server, your software code, and and somebody sends an input to your server, and all they get is an output, and there's no way they could figure out what you're doing to give that really good output, then patents may not be the way to go. Patents, after 18 months, are published, and they have to be published to be granted at the very least. Let's say you apply for a patent, and software can be a challenging area to get patents in. You certainly can do it, we do it all the time, but it can be a challenge. If you struggle to get that patent or you don't succeed at all, then your protection patent-wise isn't happening, then you've lost your opportunity to have a trade secret. But if you couldn't reverse engineer that, well, why didn't you keep it a trade secret? There's a lot of value to that approach then, commercially, for your business. Also, on the flip side, it almost seems like the same thing. Is your invention detectable? And I ask that more because could you tell if somebody else was actually implementing your trade secretable technology? If you have a patent for something and you want to be able to enforce that patent against other people, and that's not the only reason to get a patent, as I said, things like investors and such might just want to see patents, but if you want a patent for actually protecting your business, and you will never be able to tell that your competitors are doing what you're doing, then the patent may not be all that valuable because you're going to have to go through a lot of effort to prove that they're actually doing what you do. And if you're wrong, that could be a very expensive litigation process to find out you're wrong. So again, in those instances, if you can't detect that competitors are doing what you're doing, a trade secret suddenly starts to look very attractive. Almost similar to what I've just said in some senses, it could be that your invention is excluded from patentability. It could be a business method, could be a particularly, a particular piece of software that might struggle for patentability. It might not hit that technical requirement that the patent officers are looking for. If it doesn't meet those requirements, or it's going to be on the borderline, then it may be worth considering protecting by a trade secret. It may not be the way to go, patent might still be the right way, but it's always worth considering. We should never have a default option for every invention we come up with. Also, it just might be commercial data, like Camilla said earlier. If you have your client database, you have a particular method of doing things within your business that isn't a patentable invention, but it's still very valuable, well then, the answer is definitely the trade secret. Protect that with a trade secret. As I've alluded to, you tend to find, I preempt myself, what are your investors looking for? The investors can be very valuable depending on the size of your business. And if they're looking for patents, if you know that a particular investor or group of investors you're targeting, and they like to look for patents, then sure, maybe a patent directed to a very specific part of your invention is the way to go. Maybe you can patent a certain part of the invention while keeping another part of it a trade secret. In the area of AI, and I'm preempting myself again on this final point in this slide, if you have a very good AI system that works really well, maybe that's worth patenting depending on how the AI is working. But your training data, that's separate. And normally, the vast majority of AI-based patents, the training data isn't necessary to include in that patent application. And so you can keep your training data as a trade secret, maybe patent the way the software is working, and then you've got double protection. Even if people could get around your patent or knock out your patent or something, they wouldn't have your really good training data, and so they still wouldn't have a system that's working as well as yours does. That's my my 2 cents, as it were, on whether to patent or trade secret. Carolina, I hope that gives you some answer to your question.
Yeah, actually, I think that is very interesting because it comes to the strategy and to the technology. But I still have a question when it comes to the process, because when you talk about patent, it looks for me that is more straightforward. When you patent something, you forbidding others to actually copy your invention. While when we talk about trade secrets, it feels that it's more an internal strategy and long-term strategy that you have to build every day. How complex is the process? How costly? Because normally we said that patents is very costly, but since this is a long-term strategy when you talk about trade secrets, how does it look like?
Yeah, that's a wonderful question. I love it. Excuse me, I have a cough. So it is an ongoing burden on your business, in a sense, a trade secret strategy. But so long as you implement it and build intellectual property in general into the culture of your business, including the trade secret strategy, it shouldn't be that burdensome, and it shouldn't be that costly either. What you need is a good method, a good way to keep track of what your trade secrets are, what value they have, and what measures you're taking to keep those trade secrets secret. Now, it could be as simple as an Excel spreadsheet, but there are certainly more sophisticated ways that you can do that, and we have a few that we tend to recommend to our clients when we work with them directly. But ultimately, you want to just be able to keep logs of all this information and make sure that your employees know about it. And this can be really easily done, though. You know, you're having monthly meetings. Everyone's having meetings all the time these days, many of them by Skype and Teams. You know, agenda item, IP. What new IP have we come up with this month? Well, we had this really good idea to do this. Okay, we should check if we want to keep that as a trade secret or a patent. If it's a trade secret, let's put it in the Excel spreadsheet or more sophisticated system and have a record of that and make sure the people who are working with that information, who are allowed that information, know that that's a trade secret, and make sure that we have somewhere we can reference what the trade secrets are. And if it's going to be a patent, let's get that out to the patent attorneys or our in-house patent specialists and get that invention going. So these are the sort of things we want to keep in mind. So it's not a big burden cost-wise, but it has to be built into your culture of your company. And as long as you can do that, you're in a good position.
Great. Thank you, Christopher.
Oh, that's absolutely fine. And on that, I'm going to pass over to Graham. And Graham has some very specific experiences in this field that he can talk about. It's going to be great. Over to you, Graham.
Thanks, Chris, and thanks, Camilla. So yes, Graham McCallum, and my background is that I worked for 5 or 6 years with BlackBerry in-house in their patent department, and as part of that, I was responsible for a lot of the network telecommunications cellular network cases. So as a lot of you will recognise, this is a very sort of basic diagram of software architecture model going from the file layer, radio and baseband up to the application layer. So one of our main concerns in BlackBerry was looking at patentability of the layers, basic layers 1 up to 3, so up to around about the network layer. And a big part of that when we were reviewing invention disclosures was whether they were patentable, but also how detectable they were. Should we keep it as a trade secret, or should we disclose the invention and patent it? And there are a number of criteria we used within BlackBerry to try and assess what the most appropriate form of protection was. And if you do decide to keep it a trade secret, documentation is important, because it's not just putting it on an Excel spreadsheet, because an Excel spreadsheet doesn't document what the trade secret is. It just gives you a headline title. So you need some sort of document management system, especially if you're dealing with a lot of trade secrets, to contain that information, and you can refer back to it later. So if you believe that somebody has copied your trade secret, you not only need to know a headline title or a code for the trade secret, you need to then be able to go back and identify the original documentation for that trade secret. So when we were looking at inventions in BlackBerry, and we'd have probably a few hundred a month invention disclosures from employees, always the big thing was detectability. So for these, especially in the lower layer, as you get into the file layer, is the invention detectable? Sometimes the invention is software, and sometimes it's a combination of software and hardware. So the issues where if you sell a product incorporating the invention, would a competitor ever be able to analyze the product and determine what the invention was? And to flip that around, the question is, well, if a competitor does copy the invention, how are we ever going to know whether a competitor is actually using the invention? Is it likely that we would be able to strip down their device and assess whether or not there's a reasonable likelihood that they're using the invention? And if the answer to these questions were no, it tended to be that we would postbox these as trade secrets. As you get higher up the protocol stack, there's more messaging going in and out of the devices, and so it becomes more detectable as to what inventions are in the upper layers and what's going on. But down in the lower layers, especially the PHY layer, it can be either extremely difficult or even impossible to know what's happening down there, even if you've got source code. So for example, you may have, even if you've got access to your competitor's source code, which you have to ask yourself, is that a breach of a trade secret to start with, having access to your competitor's source code? But even if you did have it, if an invention is implemented in both a combination of software and hardware, how are you going to know what the hardware does? So, so the detectability was always a big issue in determining whether we went for trade secrets or whether we filed patent applications. And if we could go on to the next slide, Chris. So looking at some of the criteria we'd use when assessing whether to proceed with a patent application or a trade secret was, first of all, the implementation. Is the invention implemented in hardware? Is it implemented in software? Or is it implemented in a combination of hardware and software? And depending on how it was implemented, how detectable would the invention be, both in terms of the product we're selling, but also would we be able to identify whether competitors were using our invention? So there was always the product. Would it be possible to reverse engineer our product for competitors to find out? And would we be able to tell whether a competitor is actually using the invention? There is an exception to these, to the implementation and detectability, and that is if the invention is standards related. So if you think the invention is going to go into a standard, it's going to be implemented into a standard, adopted, then the invention is inevitably going to be disclosed in the standard, and that's probably a good reason for patenting it, because if you know that if a competitor's product is compliant with the standard, then they must have implemented the invention if it's a standards essential patent, or it's an invention that's essential to carrying out the standard. So that would be a good reason to basically ignore the questions and criteria on implementation and detectability above, and to file a patent application anyway to try and obtain a standards essential patent. And then, as we've discussed, Camilla first of all discussed, and Chris as well, is documentation is very important, extremely important. You've got to have the trade secret documented. And of course, keep it secret. There are lots of different anecdotal stories about how different companies keep their, if you like, their family jewels secret, how they maintain that secrecy. There's one story about Drambuie, which is a whiskey liqueur, where the recipe for it is actually kept in two halves and kept in separate safes, and no one person knows the whole recipe. The idea being that two people know the recipe, or the two people know the recipe and they each know half of the recipe. So how true that is, I don't know, but that is a sort of anecdotal story about how some companies will try and keep their trade secret, limiting who knows about the trade secret and limiting access to it, and perhaps in extreme cases for extremely invaluable trade secrets, actually only having certain people knowing certain aspects of the trade secret as well. And it was important, obviously, is having these steps that you're taking documented as well.
I have a question there, because as I see, it's very important to document your trade secrets in order to defend it, to prove that it's yours.
Yeah.
But at the same time, it's very increasing all the cyber crimes. Do we have any protection in both laws that will help companies, or how does it look like?
Well, the cybercrime would be a breach of the trade secret, and it's a risk. I mean, obviously, the alternative is to go down the paper route, and to document it in paper, but that has risks as well. So, for example, fires or flood damage. So, I don't think it doesn't matter how you hold your trade secret. In terms of there's a difference between holding it secret and actually maintaining that documentation, whether it's in paper form or whether it's in virtual form. There is always a risk that there could be damage to that documentation, either by fire or by cyber crime, or some other loss of data. And you can minimize risk, but you can never eliminate risk.
Right. Thank you.
So that we got next slide, Chris. So that finishes my part of the presentation, and now I think we're handing back to Camilla for final thoughts.
Yes, thank you. I don't have much else to say because I think we basically said it all. But I think looking at it as a fragile thing that needs to be taken care of. Otherwise, you risk that it's gone. And I think the key to keep in mind is that when it's gone, can't get it back again. So having these measurements in place and having a general awareness in the company, it's really, really important. And it's sometimes, and to begin with, it can start with the small steps, but these small steps can have initially a big impact, and then you can basically move on from there. So I think that's the key take home, that you don't have to be an expert on day one, but if you don't take the steps, you lose out on the possibility. And I think really that trade secrets is a key in increasing the value of your companies and to open up new opportunities for investors, collaborators, and just generating more income. Yeah.
Camilla, I have my last question. I don't see questions in the chat. My last question. I believe that when it comes to intellectual property, we always discuss about the balance between innovation and protection, right? When it comes to trade secrets, it looks like that's something that may be a challenge because we are trying to protect information doesn't go from certain employees, mainly internally when we are talking about employees. How do we balance so we also promote innovation in the company?
Yeah, I don't necessarily, it's a good question, but I don't think, in my mind at least, there is no conflict there, because the trade secrets should be made, you should have access to the trade secret if it's in your area, and you can continue to refine and develop on these trade secrets, and then you generate new trade secrets or new patents or new IP. And the same goes if you work in sales, your client list will expand, you get new options, possibilities, and ideas. So I don't see it as an obstacle to innovation. No.
It's just about knowing the right people to have access to the information and to have a strategy.
Yes, exactly.
Yeah, I mean, I would agree completely with what Camilla said, that you shouldn't be seen as an obstacle to innovation. It's more a question of, once you've innovated in whatever area, whether it's a technical innovation or a commercial innovation, is how do you go about protecting that innovation? It's a question more of protection rather than an obstacle to it. it's certainly something that you don't want to stop innovating because of you've got concerns about how you're going to hold your trade secrets. You should be thinking about how you're going to hold them, how you're going to meet the trade secret requirements. And if that's appropriate for your business and as an alternative to patent or other IP protection.
Great. Thank you so much. I think that it has been very, very interesting today. Thank you, Christopher, Camilla, and Graham. I would like to thank everybody that has been today, that has participated, and I hope to see you next time when we have our next IP speaker series. Thank you so much to everybody.